Welcome to this explainer. Today, we're going to unravel what I like to call a massive, densely woven web. We're taking India's incredibly complex matrix of environmental laws and, well, transforming it into a clear, fascinating blueprint. Think of it like a giant puzzle. We're going to map out exactly how a nation of over 1 billion people legally protects its natural resources, its wildlife, and, honestly, its future. Let's get right into it. Over 25 distinct statutory bodies and acronyms. You've got the CCPB, NTCA, CAQM, NDMA. I mean, it looks like an absolute alphabet soup, doesn't it? But here's the thing. This staggering density, it's the sheer literal framework of India's environmental protection. Each one of these acronyms represents a crucial pillar holding up the sky, the forests, and the water. So together, we're going to build this net and figure out exactly how all these pieces connect. Okay, let's dive into this roadmap. To keep us from getting totally overwhelmed, we've broken this massive legal matrix into 5 clear compartments. First, the environmental umbrella. Second, forests and tribal rights. Third, protecting wildlife and biodiversity. Fourth, energy, disasters, and nuclear. And finally, justice and enforcement. Section 1, the environmental umbrella. So we really need to start by looking at the broad canopy of laws protecting the fundamental elements of human survival. We're talking about the air we breathe, the water we drink, and the land we stand on. Now, massive regulatory frameworks, they don't just happen out of nowhere, right? They're triggered. The 1972 Stockholm Conference was the global spark that actually birthed India's Air Act of 1981. But the ultimate catalyst? Well, that came from tragedy. The devastating Bhopal gas disaster was the direct trigger for the Environmental Protection Act, or EPA, of 1986. That became the massive umbrella legislation designed to basically coordinate all environmental laws. What's really interesting is the federal tug-of-war happening among the big 3 laws. Because water is a state subject, the Water Act of 1974 relies heavily on cooperative federalism between the center and the states. But air and the EPA, they give the central government a massive hammer. We're talking absolute override power to shut down polluters and issue direct commands straight from the top. Now, to actually enforce these laws, there is an exact structured chain of command. Power flows systematically right from the top. It starts at the Ministry of Environment, Forest, and Climate Change, filters down to the Central Pollution Control Board, then it's delegated to the State Pollution Control Boards, all the way down to the local field stations. So what does this actually mean? It means the rules made in a central ministry are ultimately enforced by a local officer inspecting a factory right in your town. Moving on to Section 2, Forests and Tribal Rights. Here, we're going to explore this fascinating and honestly very delicate legal tension between protecting the trees and protecting the indigenous people who actually live among them. When we compare the laws, we can clearly see 2 historically distinct approaches to forest management. The Indian Forest Act of 1927, that is fundamentally a classification system. It sorts lands into reserved, protected, and village forests. But on the other hand, the Forest Conservation Act of 1980 is designed specifically as a gatekeeper. Its main job is to regulate and strictly limit the diversion of forest land for non-forest uses. Now, here is a surprising fact nestled in the legal updates. Back in 2017, bamboo was officially delisted. Yup, it is no longer classified as a tree under the Indian Forest Act when it's grown outside forest areas. And this was a real game changer. By legally stripping bamboo of its tree status, it removed massive bureaucratic hurdles. Suddenly, local farmers could harvest and sell it freely, completely transforming their economic reality. But of course, the legal landscape is constantly shifting. Under a highly significant 2023 amendment, the Forest Conservation Act was actually renamed, and some major new strategic exemptions were created. Get this. Now, an incredible 100 kilometers of forest land, situated alongside international borders, are totally exempt from standard central forest clearance. And that's alongside a 10-hectare exemption specifically carved out for security infrastructure. So, the crucial question is, where do the people fit in? Well, the Forest Rights Act of 2006 completely shifted the paradigm. Instead of the Ministry of Environment, this one actually falls under the Ministry of Tribal Affairs. Power is surprisingly handed down to the local village assembly, the Gram Sabha. This is a massive democratic shift. It puts the power to manage the forest directly into the hands of the people who live in it, granting them title rights, use rights for minor produce, relief, and real forest management rights. All right, Section 3, Protecting Wildlife and Biodiversity. Let's transition away from the abstract habitats and look at the highly specific frameworks built to protect the actual creatures living within them. The absolute cornerstone here is the Wildlife Protection Act of 1972. A recent 2022 amendment really streamlines things, taking its protection categories from 6 down to just 4 distinct schedules. But note the immense gravitas given to wildlife here. The apex advisory body that alters protected area boundaries, it isn't just run by mid-level bureaucrats. It's chaired directly by the Prime Minister of India. No small deal, right? Now here's a fascinating legal distinction that you might not expect. While wild tigers are fiercely protected under the Environment Ministry, a domestic cow's welfare is treated completely differently. Governed by the Prevention of Cruelty to Animals Act of 1960, the oversight of domestic animals was actually transferred entirely away from the Environment Ministry in 2019. It moved over to the Ministry of Fisheries, Animal Husbandry and Dairying. Section 4. Energy, Disasters, and Nuclear. As India develops at lightning speed, let's shift our focus to how this legal matrix handles modern frontiers: energy markets, disaster response, and the future of nuclear power. Under the Energy Conservation Act, we see a really crucial evolution. This law created the Bureau of Energy Efficiency and instituted market mechanisms like the Perform, Achieve, and Trade Scheme. Plus, it was heavily updated in 2022 to introduce a domestic carbon credit trading scheme. The philosophy here is simple but radical. Don't just punish the polluters, make energy efficiency highly profitable. When extreme events happen, chaos is absolutely the enemy. That's exactly why the Disaster Management Act of 2005 establishes an incredibly rigid, precise hierarchy. Leadership cascades perfectly downward. The Prime Minister chairs the national authority. The Chief Minister chairs the state level, straight down to the district collector who manages the local boots-on-the-ground response. Let's look at how all this builds into the future of energy. A massive, massive recent evolution in the matrix is the SHANTI Act of 2025. Replacing an old law from way back in 1962, this completely redefines regulation by officially opening up India's nuclear energy sector to private participation, all overseen, of course, by the Atomic Energy Regulatory Board. Finally, Section 5, Justice and Enforcement. For our last section, we really have to ask the big question. How does a legal net this massive actually enforce its own rules? Enter the National Green Tribunal, or the NGT, which was established in 2010. Now, this is grounded in Article 21 of the Constitution, the right to a healthy environment, but the NGT isn't your average court. Anyone familiar with the traditional court system knows how incredibly slow it can be. But the NGT, it operates with a strict, mandatory requirement to dispose of cases within exactly 6 months. It is engineered for specialized, pure speed. And this brilliantly illustrates the sheer complexity of this matrix. The Green Tribunal has immense quasi-judicial power over water, air, and forest conservation laws. But look closely at the exceptions. Surprisingly, actual wildlife and the historic Indian forests of 1927 are entirely outside its jurisdiction. Who would have guessed that? So, we've mapped out the hierarchy, the triggers, and the exceptions. But as we step back to look at this vast matrix of acronyms, ministries, and tribunals, I want to leave you with one final provocative thought. Does this dense, highly overlapping network of central and state authorities guarantee an impenetrable shield for India's ecology? Or does this sheer density risk creating an intricate bureaucratic maze where true enforcement might just get lost? It's a complex balance, for sure, and understanding these structures is the absolutely crucial first step to seeing how it all works. Thank you so much for joining me for this explainer.